We're ready.
Welcome, members and guests. Today is Tuesday, March the 15th, 2022. I hereby call the Civil Justice Subcommittee to order. Ms. TJ, take the roll.
Good morning. Representatives Clemens, Curcio,
Here.
Farmer, Garrett, Griffey, Ogles, Parkinson, Ramsey, Chairman Russell. Chairman, you have a quorum.
Thank you. Members, are there any personal orders or announcements before we begin this morning? Seeing none, we're going to take care of a few items on the calendar. First, item number 1, without objections, Road to the Hill. Number 5, House Bill 2605, off notice. Number 11, House Bill 2350, Road to the Hill. Number 14, House Bill 1839, off notice. And item 15, House Bill 2401, Road to the Hill. First up is and item 7, House Bill 1940 is off notice. That brings us to the top of our calendar. Item number 2, House Bill 2452 by Representative Weaver. Representative Weaver, do I have a motion? We have a motion, and we do have a second. Representative Weaver, you're recognized on House Bill 2452.
Thank you, Chairman. Thank you, members. What I tend to do here is what this bill basically does is you cannot, on the basis of vaccination status, discriminate. Boom, that's the bill. But what I want to go ahead and walk you through the language and take each section so that you know what this bill does and what it does not. This bill would supersede the protections for discrimination by vaccination status found in Title 14, which is the omnibus bill that we passed in the third extraordinary session of last year. It amends our Human Rights Code in Title 4 by adding a new part. It applies across the board to any and all communicable diseases and not just COVID-19. It has no expiration date, where Title 14 currently expires on July 1, 2023. It fully respects the rights of the General Assembly to make law for our state and creates no exceptions for unconstitutional federal overreach. All Tennesseans deserve the constitutional right to be equally protected under the Tennessee law. Next, it protects persons from being discriminated against in any manner by government entities, public officers, employers, and public places of public accommodations based on 3 things: vaccination status, immunity status, and whether the individual has an immunity passport. If you'll notice, there's definitions of vaccination status. It's defined as having 1 or more doses of a vaccine, any vaccine for any communicable disease. Immunity status means the ability of an individual's body to demonstrate an immune response or to defend itself against a communicable disease. An immunity passport is a document, test result, digital record, or software application indicating that an individual has immunity to a communicable disease through vaccination or infection and recovery. Simply put, members, this bill would protect a person's ability to engage in commerce and participate in gainful employment while respecting that person's medical privacy and their ability to make their own medical decisions when it comes to the choice of receiving a vaccine. Per subsection B, this bill will not impact a public or private school's ability to make vaccine requirements per existing law. However, they must allow for religious exemptions. Outside of an executive order made during a declared emergency, per Section C, it would be unlawful to require the testing of an individual without a reasonable suspicion that they are sick. And please note that if there is reason to believe an individual is sick due to perceivable symptoms, a requirement for testing is allowed under this law, but this must be done on an individual basis. This is in no way deals with an employer's ability to test for substance abuse or other work-related or industry-specific testing. This deals solely with testing an individual for communicable diseases. Under subsection D, This deals with healthcare facilities, nursing homes, and assisted living facilities. You may not fire an employee or refuse services to patients or visitors based on vaccination status. May require vaccination status of employees, patients, and visitors for the sole purpose of providing reasonable accommodations to protect the health and safety of others. And reasonable accommodations are not specifically defined in this bill, and they rely on existing laws and regulations as to what those may be. And generally, they must provide for the full and equal employment of all services provided. Thereby, services and/or employment cannot be denied to individuals based on vaccination status. Section 421.1103 allows an individual to file a complaint with the Tennessee Human Rights Commission as a result of any violations of this new law. The complaints would be handled just as any other human rights complaint. The Commission would follow standard procedures as already established in the law in Part 3 of this chapter. The fiscal note on this bill is found to be not significant, stating it is not estimated to significantly increase the number of phone calls, online complaint submittals, or caseload processing on behalf of the Tennessee Human Rights Commission. And per current law, individuals still retain the right to private cause of action. The teeth in the bill is found in the next section, 2 and 3. In the ability for the Tennessee Human Rights Commission to access penalties if violations of the law occur. May assess penalty of up to $10,000 for one occurrence. May assess penalty up to $25,000 for the second occurrence in a 5-year period. Must assess a penalty of $50,000 for third and each subsequent occurrence within a 7-year period. The Tennessee Human Rights Commission, through the Attorney General's office, may also seek remedy in the appropriate chancery court for violations of this law. An individual also reserves a private right to cause of action if penalties are not assessed and legal action is not taken by the Commission as already provided in current law for violation of this chapter. So basically, I broke down the whole bill in front of you. I just want to, before I take any questions from you, I just want to say that you and I here today as state legislators are elected by the people to protect constitutional rights. That's what we were deemed to do. And we swore our oath to protect those rights. But we have been through some crazy stuff in the last 2 years. I know personally many people who were fired from their job. The music industry alone has prevented musicians from traveling and touring with groups, venues. I have a whole list and slew of them. I have lists of personal musicians who were not allowed to play at the Bluebird in the round because they were not vaccinated or could not show a passport. Tennesseans are facing impending discrimination for their own personal health choices. And again, as elected folks of Tennessee, we need to stand by, we need to step up to the plate and stand by our constituents. They're losing their livelihoods, and it just simply isn't right. Thank you, Mr. Chairman.
Thank you, sponsor, and for that description. Do we have any questions? Representative Griffey, you're recognized.
Thank you, thank you, Mr. Chairman, and thank you, Representative, for bringing this legislation. If my position isn't clearly known about these vaccines and employers using vaccines and vaccines passports as a condition of employment, I want to be clear on the record about that. It's my position we all have a constitutional fundamental right to bodily integrity, to not be subjected to any offensive contact, injections, anything to our body, unless we consent to them, and that's informed consent. There are, of course, situations where your constitutional rights can be taken away from you with due process through a court or something like that. And you know, if we as a legislature who are charged with protecting the rights of our constituents and the voters and citizens of the state, you know, it's our duty to protect those rights. And I am saddened that I don't feel like we've gone far enough to do that. If these vaccines were so effective, we should have passed a law that says everyone has to get one. And I think the science has now come out and demonstrated that the vaccines do not prevent transmission. They don't. That's not how the vaccines work. So if they don't prevent transmission, why are we forcing people to get vaccines? The survival rate on COVID is like 99.997 for children 12 and under. Adults, I think it's the 97, 98, and it certainly gets higher for those in the highest risk category the older you are. But it's much less than that for folks under 60, 65. I wish, with those kind of risks, I think it's up to each individual to make a decision whether to get a vaccine or not get a vaccine. And I'm frustrated that we are allowing employers to impose conditions on employees that really don't have a basis in science and fact. I'm going to support your bill. I'm co-sponsor of your bill. And I would urge the committee to pass it. So thank you.
Thank you, Representative Griffey. Sponsor, would you like to reply to that?
Yes, thank you. I will add to the comment, whether you believe in the vaccine or not, this bill is not going to address that. This bill totally sticks to the one question. You cannot discriminate on vaccination or the status of vaccination. This bill deals even going forward. Who knows what's going to come down the pike for next requirement? This bill will protect an individual, and you just cannot discriminate against it. Period. It's very simple. It's not hard to understand. I just know that, and I believe you could say the same thing, Chairman, that never in my lifetime have I seen such a overreach of government interfere with people's personal choice of their health. Never before. Federal government. And it can stop here at the state. Montana passed this same law. So if you go to Montana and they require you to take a vaccination, they are going to be breaking the law. And the good news about it is the leadership, or the governor and the attorney general of Montana, actually enforced it. And that's a really good thing when we have all forms of government in the state standing behind the citizens of that state. We can curb the power at the state level, especially now, and we should step up to the plate and be courageous for the people of Tennessee and say, not in Tennessee. Any business can come here. We welcome you to come here. But when it comes to you making decisions of the health care choices of the employees, that's forbidden, and you cannot do that. It's simple.
Thank you. And Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And does this restrict private business owners from being able to make decisions as to entry into their venues?
Representative Weaver.
This bill says you cannot discriminate on vaccination status. I have a young lady who sent me this. I know the lady personally. Employed by the Country Music Hall of Fame. I was not allowed to eat in the building because I was unvaccinated. I was required to eat outside. I was not reimbursed for the meals I purchased in order to eat inside. I was unable to sit in the break or the lunchroom and talk with people. I was required to wear a mask from the moment I stepped onto the museum's property. I was required to wear a red letter or blue bracelet to show that I was unvaccinated. Vaccinated staff wore a different color. When the mask requirement was temporarily dropped for vaccinated staff, I was still required to wear one. I and other unvaccinated persons were the targets of repeated hate speech from security, co-workers, members of the administration, and occasionally the guests. I was removed from my position in sales box office because I was unvaccinated and not allowed to sit within a certain vicinity of those who were vaccinated. I was asked daily by a security member upon check in if I was vaccinated. I was targeted by the head of security on a regular basis. On another, he made rude and degrading remarks towards me. I was required to quarantine for a week without pay after traveling outside of a certain vicinity of my residence. For example, if I spent the night at a friend's house 25 miles away, I was required to quarantine in this manner. Fully vaccinated staff were not. It goes on and on and on. In answer to your question,
It sounds like yes.
it's not, yeah.
Okay, the answer is yes. All right, so my question then is, how does this different from restricting people from smoking inside a venue?
Representative Weaver.
I mean, this is an injection. This is a lot different than smoking.
Representative Clemens.
Well, I mean, you're using broad, general terms about people's constitutional rights and their ability to do whatever they want with regards to their health. So I'm just asking, you inhale into your lungs smoke and nicotine, and we've prohibited that and allowed business owners to make a decision as to whether or not you could do that indoors, and you used the musician's example in your presentation. So I'm just curious how this is different, because you're affecting the health of others, not only yourself, but those around you. So I'm curious how this is different.
Representative Weaver.
I would say that these are apples and oranges. You're not even comparing the same two ingredients. You're talking about an injection that is being placed in someone that we have. I mean, I'm not here to argue the science of the vaccine, sir. I am not here to do that. I would just say that you're not even comparing two of the same things.
Representative Clemens.
Okay, thank you. So you say in here this doesn't pertain to schools and existing vaccination requirements that are already in statute for public schools or private schools, nursery schools, preschools, or child care facilities. So this just pertains to the COVID vaccine. Is that correct?
Representative Weaver.
That is not correct. This pertains to all vaccines, and you must honor a religious exemption or medical exemption, and that's not being done on the workforce either.
Representative Clemens.
Yeah, I understand that, but the language of your legislation says notwithstanding that, and you always have those exemptions. That's already there. But these provisions that you're trying to put into law don't apply to the vaccination requirements that are already set forth for public schools. So if there's such an objection to vaccinations, why are you excluding those current statutes and vaccination requirements?
Representative Weaver.
Again, I'm just speaking to discrimination on your vaccination status. That's all this deals with. And we have in the law that you have to honor religious exemptions, but that's not happening. And if it is happening, they run you through long months of getting a reply. It's just there. It's not being done out there on the workforce. It's not being adhered to.
Representative Clemens.
Thank you, Mr. Chairman. And I'll just leave it with one more. The bill also says that the bill declares it unlawful discriminatory practice for an individual or government entity or a private business or employer to acquire testing of an individual for a communicable disease who is by a reasonable standard showing no known or perceivable symptoms of a communicable disease. What is that reasonable person standard? Is that the standard of a medical professional or just your average citizen?
Representative Weaver.
Again, I think every individual knows if they're sick or not. And if there's no, it says in there, perceivable symptoms.
Well, this is a subjective standard from a third party, so this isn't with regards to the person themselves. You've got in here the reasonable person standard. So I'm curious as to whom the reasonable standard applies. Is it a medical professional or a average citizen?
Representative Weaver.
This would be it says, is sick due to perceivable symptoms, a requirement for testing is allowed under the law, but this must be done on an individual basis.
Representative Clemens.
Thank you, Mr. Chairman. That's all I have.
Do we have any other questions? Representative Ogles.
Thank you, Mr. Chairman. To the sponsor, thank you for bringing this piece of legislation. I think it's a great piece of legislation, and I was thrilled to see my name is listed so high on the list. I've just been amazed that we're not standing up for the religious exemption of the citizens of this state, and I find it appalling that we stand and pray as members of the General Assembly every session before we start every session, but yet we've been so reluctant to stand up for these people. I don't understand it, I don't believe it, and I thought I would never see this. Thank you to the sponsor.
Representative Weaver.
Thank you for that. And again, in the last 2 years, there's things happening in our state I never would thought happen in a state that is led by conservatives, the majority of conservative Republicans, and we are turning our backs on our citizens in the workplace that are literally making a choice between their health choice and their livelihood. It isn't right, members. It's not right at all. Again, I've never seen such federal and state overreach on vaccinations, and this should be the U.S. of A. And every now and then I have to shake my head and wonder where exactly we're living.
Question's been called. We got one question out here. You want to withdraw? Representative Griffey, he's going to withdraw.
Thank you, Mr. Chairman, and thank you, Chairman Farmer. I just wanted to try to assist my good friend from Davidson County on the comparison of smoking versus this bill. Smoking's obviously a voluntary behavior that someone engages in. It lights up, it smells, you can see it. It's particles of air that anybody can control by not smoking. The virus is something that originated from China, which to date, I have yet to see any of our federal elected leaders do anything to try to hold China responsible for. This virus is in the air. You can't control it. You can mask, which there's arguments whether it's effective or not effective, but you still can't control it. And it's going to be transmitted from person to person, and that's how the human species has always fought off viruses. Our immune systems fight it, and our bodies recover it. We get immunity. That's how our immune systems work. And that's what's happening with this thing. The vaccines are not working. I think the Pfizer guy, the CEO of Pfizer, is talking about a fourth jab now. So I just wanted to share that info, and like my good friend from Williamson County, I just think it's completely regrettable and shameful that we're not standing up for the religious beliefs of our citizens. Thank you, Mr. Chairman. Thank you, Chairman Farmer.
Thank you for that. And unless you got anything else, sponsor, the question's been called. And we'll be voting on House Bill 2452 to send to full civil. All those in favor signify by saying aye. Aye. Opposed, no.
Nope.
The ayes have it. Congratulations, full civil.
Thank you.
Y'all can either leave or sit there quietly. Those that came to testify, I apologize. The notification wasn't done in time, so thank you for being here. You're welcome to stay, but we got to be quiet. Next up, item number 3, House Bill 2548 by Representative Alexander. Second. We got a motion and a second. Representative Alexander, you're recognized, and we do have an amendment.
Yes. Thank you, Chairman. Thank you, Committee.
Okay, we got a motion and a second on the amendment. Would you give us that drafting code?
Yes, 014440.
014440. That's what I've got. We got a motion and a second, and you are recognized on the amendment.
Thank you. When I was knocking on doors campaigning, I met a gentleman who said to me, I hope that you can do something about this. He said, I allowed my son to live in a rental house that I had, and unbeknownst to me, he let someone live there with him who needed a place to stay just for a couple weeks. He said, I couldn't get the man off the property at all. He said he ended up being a man that was running a chop shop for motorcycles. I went there and there were motorcycles all over the yard of my property. Found out he was running an illegal operation, couldn't get him off, and he said it cost me $30,000 through the courts to get him off. The reason I wanted to run this bill is because it allowed people to kick people off of their property that they didn't want on there anymore. It's their property, they own it, and as long as they were older than 16 years old and they weren't disabled, then they had a right to remove those people from the property. I had some questions, legal questions, and so I went to Representative Farmer about it, and I went to Chairman Russell about it, and I went to Johnny Garrett about it, and I want us to run a bill, but I want it to be right. And I want it to help the citizens who own property and pay taxes in this state. So with your all's permission, I would like for us to meet together over the summer and really come up with a great bill that's powerful and that helps our citizens. So without further notice, I'd like to take this bill off of notice for the time being.
Well, thank you for that, sponsor. We definitely want to get it right, and I appreciate that explanation, and we'll take the bill off notice, but Representative Ogles would like to be recognized.
Thank you, Chairman. And to the sponsor, I just want to commend you on doing this. I've actually run into a similar circumstance some years ago with somebody I had on my property, and it's amazing how tolerant even the courts are with documentation and the right you have to remove individuals,
Right.
even when you present to the court that the fact that they're not only in defiance of a legal document, but it's your right as a property owner. So I commend what you're doing. I hope we look at this very well over the summer and we get this right. But thank you for bringing this piece of legislation. It's
Thank
much
you.
needed.
Yeah, thank you.
Thank you, Representative Ogles, and thank you, Representative Alexander. Without objection, off notice.
Thank you, committee.
Next up, item number 4, House Bill 2521 by Representative Sexton. We got a motion. Do we have a second? Second. We've got a second. Representative Sexton, I'm showing an amendment. Do you have an amendment you'd like to run today?
Yes, the drafting code is 15280.
That's correct, 015280. We got a motion and a second, and Chairman Sexton, you're recognized on the amendment.
Mr. Chairman, I would request a roll call vote on this, please.
We'll roll call it.
What this bill does, last year we passed Governor Lee's permitless carry legislation, and a lot of people think that it's approximately 2/3 of the United States believe that this permitless carry has reciprocity with Tennessee, but that's not exactly true. We mistakenly believe the legislation protects us. But in gun-free zones, you could still be charged with a crime if you're carrying where they're posted that it's a gun-free zone. So what we do with this bill, and we like to call it no harm, no foul. If you walk into a store or building that's posted no guns, then you're asked, if someone sees that, then you're just simply asked to leave, that it's a gun-free zone. You leave, then there's no problem. If you don't, then you can be charged at that point. So basically, that's all that this bill does. It's just no harm, no foul, and I'll be willing to answer any questions.
Thank you, Chairman. And am I correct by saying the amendment makes the bill?
Yes.
Would you want to go ahead and put the amendment on?
Yes.
Okay, and would you like a roll call on the amendment or just the bill?
Both, yeah.
Okay, we're voting to put Amendment 015280 on to House Bill 2521. Ms. TJ, take the vote.
Representative Clemens?
We're voting to place the amendment on the bill.
Yes.
Curcio? Farmer? Garrett? Griffey?
Yes.
Ogles?
Yes.
Parkinson? Ramsey? Chairman Russell?
Yes. Okay, we got the amendment on the bill, and we'll gavel that in. And we've got some testimony, so we'll go out of session and hear from them. First up will be Elizabeth Stroker with the Department of Safety. And of course, you'll have 3 minutes just like normal, and you'll punch the little button. The light will turn red, and our official timekeeper here will keep the time.
Elizabeth Stroker, Legislative Director for the Department of Safety. I'm here today to express the Department of Safety's opposition to this bill based on how much it would impact both the state, the department, and law enforcement in general. This would effectively eliminate the posting option for state, local, or private businesses to prevent firearms within their facilities because of how many restrictions are required to be able to do that. To start with, you have to hold a public hearing. Unsure where that would be, but you would have to hold a public hearing to be able to prevent firearms within your facility, which would then have to be held annually. You have to post new signage, which doesn't include the law enforcement exemption currently allowed, which is also could be confusing. Additionally, we would have to have armed security, commissioned officers. Reasonable security is what it is. It doesn't say specifically for what it would have to be for a state agency. For anyone that's entering the building in the public, you have to have security at every entrance. You have to have metal detectors at every entrance. You also, if you do all of those things, you still have to give someone written notice that they cannot carry if they try to, and then oral notice. And then, if you do cite them, you cannot confiscate the weapon, which as a lot of our centers, we have DL centers where things can get contentious, or we have cases that are being heard with our driver improvement or forfeiture division that can be contentious, and we would have to give them the firearm back even though they are trespassing criminally, and just let them have it despite it being a potentially dangerous situation, which as much as law enforcement is doing within the state, they are strapped, their resources are strapped. This would require them to now just become security guards within every state building, any private building, any local building, as opposed to just being able to prevent firearms from within that facility. And you would also have to provide security in the parking area in case they want to keep their guns in their car, or storage facilities for the firearms. However, the state cannot pay for those. They have to be paid for by a private sponsor, which then gets into the ethical requirements of reporting gifts from private donors that are required by a state agency. So a little odd how that would work, or why that has to be done by a private entity. There are a lot of other reasons, and I won't keep going on, but because of all of those problems and how much law enforcement is already having to do, this would be a huge burden on law enforcement, as well as a potentially dangerous situation for our state agencies, where it would be best to have no firearms or only the officers that we currently have in there for protection.
Thank you for that. Any questions for the Department of Safety? Okay, Representative Griffey.
Thank you. Thank you, Mr. Chairman, and thank you, Ms. Stroker, for being here. You said it would be essentially prohibitive because of all the additional conditions. But if they allowed people to come to these meetings where they had posted with firearms, you wouldn't have all these costs and additional prohibitions. Isn't that the counter argument?
Ms. Stroker.
It could, but the situation here is that there are certain places and times and centers, DL centers, places where we're having contested hearings, where it just may be appropriate that you limit the amount of weapons in that facility just due to the nature of what's being discussed. That would apply public libraries, daycare centers. I think courts would even have to be required to allow for it at this point. So it is taking away anyone's ability to post if they believe it is in the best interest of either their business or their building based on what they are doing. And that's the problem.
Representative Clemens.
Thank you, Mr. Chairman. So let me get this straight. So if I were going to go into somewhere, there's going to be an Amazon coat check / gun check for me to check in my firearm. That's going to be required under this bill?
Ms. Stroker.
Correct, but also you could have the option of taking it back to your vehicle, but we would have to have security there to guard your car. Or you could call someone to come and pick it up, and we would have to wait for that person to get there and take the firearm from that individual for them to enter. Those are the other two options.
Representative Clemens.
So if in a dense city like Nashville, for instance, where there may not be parking, there's only public parking, and more than one person tries to come over with a car, I mean, so every person that tries to come in there with a firearm, you're going to have a different individual guarding all their different cars parked all over town for them to visit that business?
Ms. Stroker.
It says you would have to have reasonable security in the parking area. I don't know exactly what all that would mean, but potentially. Or you would have to find a private donor who would be willing to pay for lock boxes to put the firearms in while the individual is in your facility, but also still having metal detectors and security guards. Or it can't be security guards. It has to be a commissioned officer.
Representative Clemens.
No, you answered my question. Thank you.
Thank you. Anybody else for Department of Safety? Representative Ogles.
Thank you, Chairman. Thank you for being here today and testifying. We always appreciate your insight. What are we doing right now in this building as far as we've got some signs posted? Are we allowing members of the public to bring firearms into this building right now?
Ms. Stroker.
Yes, you can bring your handgun into this building with a permit, and that's checked in with the trooper station at the front desk, and they go through your bag like anyone else who comes into the building, but with a permit in this building, you can.
Representative Ogles.
Thank you, Chairman. I just always find it curious how we apply certain laws to the General Assembly and how we act and do business versus how we apply laws to the general public. But thank you.
Chairman Farmer.
I have a question for the sponsor when he gets back up. Thank you.
Thank you. Seeing no one else for safety, thank you, Ms. Stroker. Next up is Joe Stats. And Ms. Stats, you'll have 3 minutes, and if you'll press the little microphone button there, and Ben here, he'll keep the time for us. If you'll just introduce yourself to the committee and begin when you're ready.
Thank you, Chairman, committee members. My name is Joe Stats. I'm with Gun Owners of America, the Tennessee State Director, and I want to thank you for taking up this matter today. Last week in this very committee, there were a few members that voiced concerns on a bill presented by Chairman Todd. That bill addressed primarily the liability issues of 3917, 1359. Representative Sexton's bill expands on concerns that our members have voiced statewide. That is protecting their rights as well as the personal property rights. I appreciate, as a business owner in Tennessee, the concerns for personal property, but we need to find a balance. Right now, I believe it was Representative Ogles that commented last week about sometimes with vision impairment and obstructed signs, you can accidentally carry past those signs. The way the law is written currently, you are immediately charged with a criminal misdemeanor. We are asking for that to be brought more in line with 28 other states across the country that have signage laws, and simply give someone who makes a mistake the opportunity to correct that mistake before becoming an immediate criminal. So GOA supports this measure. It may not be perfect and it may have room for improvement, but we would hope that you will allow it to pass to full committee so that we could continue to work on this.
Thank you, Ms. Stats. And let's see if we got any questions. Representative Griffey.
Thank you, Chairman. Thank you, Ms. Stats, for being here. Let me ask you this. I think it's probably maybe custom in a lot of jurisdictions. I think it probably is in mine that if someone does make a mistake and happens to enter a building or thing with their firearm and didn't know the signs, they're probably asked to leave, and no harm, no foul. Mm-hmm. The problem is in some jurisdictions, some law enforcement or some property owners may insist upon a criminal prosecution. Would it satisfy, I think, the intent of the Gun Owners of America and those that are trying to seek protection for people that making innocent mistakes regarding entry to a property? Would it satisfy those groups' desires if we amended this bill to simply says a person cannot be charged if they're asked to leave and leave voluntarily?
Ms. Stutz?
Thank you. I think that would certainly come a long way with most 2A supporters. We have so many people come into Tennessee from out of state that perceive the state as a constitutional carry state and are not familiar with our state laws. We're putting them at risk of an immediate criminal charge. So from both residents and tourists alike, I think that it's sensible to consider this amendment. I know that our supporters specifically would like the opportunity to, when visiting or doing business in a government building, be able to store their firearm in a locker rather than have to leave it unattended in their vehicle, especially when there's bills presented this session that could make them a criminal for leaving it in their vehicle. So there's room for improvement that we want the opportunity to continue working toward.
Representative Griffey?
Thank you. Excuse me. Thank you for that. So I take it you would support if we could simply maybe at least give people the opportunity to voluntarily leave, whether it's at the request of the property owner or if law enforcement shows up after law enforcement says you got to leave, you're going to get charged. If they voluntarily leave, they're not going to get charged. I think that would be a huge step forward, I think, from your
Yes.
point of view and a lot of gun owners' points of view to try to avoid innocent violations of the law.
Ms. Stutz?
Yes, absolutely.
Thank you. Thank you, Chairman.
Thank you. Anyone else for Ms. Stats? And seeing none, Ms. Stats, thank you for being here. Next up is Toby Meyer. And Mr. Meyer, if you'll just make sure your red light's on, you'll have 3 minutes, and Ben, he'll keep the time and begin when you're ready. And introduce yourself to the committee.
Well, thank you, Mr. Chairman. Thank you, committee members. My name is Toby Meyer. I'm with T-Rex Arms, and I'm an attorney. And I would like to point out what this bill does and what it does not do. This bill does not prevent business owners from posting. It actually leaves several means of recourse for business owners that do want to ban firearms on their property. So one, as was pointed out, if you ban firearms on your property, or if you have any other rule on your property, and somebody refuses to comply with that and refuses to leave, that is still criminal trespass under Tennessee law, specifically Section 39-14-405. So if you have any sign up that says, for example, no shoes, no shirt, no service, and you walk in there barefoot, and you're being asked to leave, you're committing trespass. But the question is, should it automatically be a crime? In most states, it is not. Tennessee is one of very few states where that is the case. And that actually hurts business. That actually hurts tourism. Because as was correctly pointed out, imagine you come to Nashville for a visit and you end up getting charged with a crime. What taste does that leave in your mouth for Tennessee? Also, I would like to point out that there are still various locations where posting is possible, where also firearms are banned by law, even if this bill passes. For example, courts were mentioned. Courts actually are not even subject to the sections that are changed in this bill. Courts are actually governed by Tennessee Code Section 39-17-1306, and it's actually a felony to carry a firearm in a court building. So that would be completely unaffected by this bill. At the end of the day, what this bill does is, as was correctly pointed out, it gives people that want to be compliant with the law another option to remain compliant with the law. And if they refuse to do so, once they become aware of it, they are still committing a crime. There's also all kinds of other recourses against this, but basically what it does is it prevents people from accidentally becoming criminals who don't want to be so, and I think that's actually a good thing to do. Thank you.
Thank you, Mr. Meyer. Anyone for Mr. Meyer? And Representative Griffey.
Thank you, Chairman. Just briefly, the bill does, I think, require a place that's posting, a public place to put storage boxes for folks to leave their firearms and so forth. that's got a huge physical note that goes with it. Do you think the parties interested in this bill would rather get the one-time no harm, no foul enactment if we had to forego sort of providing lock boxes and all that?
I mean, that's of course a policy question that's up to the sponsor. I personally would view this as progress, definitely. It would not go anywhere near as far as this current bill does. The advantage of what the bill right now does is that it does give people that have to go into such a gun-free zone an option to do so safely and still be safe on the way there and back. All of us have to go to the DMV from time to time. All of us have to go into other locations from time to time where we do not have an option but to disarm, and that we don't have the choice to go to or not. And this is actually not such an outlandish concept. New York, which is a much less gun-friendly state than Tennessee, for example, does allow, for example, me as an attorney to go into one of their court buildings with my attorney ID and check in a firearm with security at the entrance there. So they actually provide those storage facilities. But I mean, that's a policy question. If that helps to get around the fiscal note, I leave that up to the sponsor.
Representative Griffey.
Thank you, and it does. And just one other question. You sat here when throughout last year when Governor Lee had his constitutional carry bill, and we heard all the predictions of gloom and doom by those that are anti-gun, anti-Second Amendment. And I think it's probably pretty clear to everyone those predictions of gloom and doom have not turned out in Tennessee. Would you agree with that?
I mean, observation seems to confirm that.
All right, seeing no further questions, thank you for being here, Mr. Myers.
Thank you.
Thank you. Next up is Linda McFadden. And Ms. McFadden, I hope I got that name right, but if you'll just make sure your light's on, and you'll have 3 minutes, and then the committee will have unlimited time for questions. And begin when you're ready. Now, there's a little bitty face with like 3 bars coming out of it, and there should be a red light that'll pop on whenever you press that button.
Thank you.
Thank you, Patrick.
I'm Linda McFadden Ketchum, representing Moms Demand Action for Gun Sense in America. I won't take long. We oppose this bill strongly. Guns are now the leading cause of death for children and teens in both Tennessee and the United States. This is the worst possible time to loosen our already relaxed gun laws and allow more guns in more places. This bill attempts to force private property and business owners to allow people with guns inside by requiring them to comply with strict, onerous signage requirements. They would have to give both written notice and a verbal warning to people who they suspect are in violation. It removes the Class B misdemeanor charge of up to $500 for people who violate the gun policy and replaces it with a criminal trespass charge with a $50 fine only. Private property owners wishing to prohibit guns would also have to provide security on site and in parking lots. The bill would require all state or local government entities, including juvenile facilities, mental health facilities, hospitals, libraries, and child care facilities that prohibit all firearms on their property to provide security, including metal detectors and on-duty law enforcement for their property, and require they provide free storage at the entrance for people to lock up their guns. The fiscal note on this bill, as I read it, is $74 million for the first year and $69 million annually thereafter. This figure covers state buildings only that would have to be upgraded. There's no estimate for local buildings that would have to meet new requirements or costs to privately owned properties across the state. Vote no.
Thank you for that. Any questions for Ms. Fadden? Seeing none, we thank you for being here and thank you for your comments.
Thank you.
Okay, we don't have anybody else for the comment section of this. We'll go back in session. And Chairman Sexton, you are recognized. And for a question for Chairman Farmer.
Really more of a comment, Mr. Chair.
Comment
than
away.
anything, just based off of what we've heard so far through testimony and then opening comments from our sponsor. And I appreciate the sponsor bringing this legislation. I want to start there. Got a few concerns about this. You know, aside from the general Second Amendment, you know, right to bear arms by everyone, anywhere, at any time, could you give me maybe an example of how this would help, maybe a situation where this could have helped, or I just see a lot of strain on businesses here and a lot of responsibility here. I'm just wondering why do we need to go this extra step here? Can you give me just a few examples of, and outside of the constitutional Second Amendment stance, like let's go beyond that. Let's talk about practical application.
Chairman Sexton.
Yes, certainly. Thank you for the question, and I think that's a very reasonable question. What we're trying to do here is just to remove the criminal aspect from, and I heard what you said outside of the Second Amendment, but just trying to remove the criminal aspect. If you accidentally walk into a gun-free zone and you're asked to leave, then you leave. It's no harm, no foul. That's the intent of the bill. If I might go to what Representative Griffey said about the amendment, if that would please the committee and take a lot of those other things off the bill that gives you heartburn, I'll be glad to do that. My intent is just to take the criminal aspect away from accidentally walking into a gun-free zone and you're carrying. That's really the intent. That's my intent. So,
Chairman Farmer.
Yes, and that was where I was going to go next with regards to the criminal aspect of this. I have not seen an individual prosecuted for accidentally carrying a firearm into an establishment. The only time I see a situation like that is if someone's in they get up in Gatlinburg or Pigeon Forge, and sometimes they'll get into the moonshine or something, and they'll carry their gun to a bar and end up in a fight or something. In that situation, they'll end up being charged with unlawful possession of a firearm because they were intoxicated into an establishment when they didn't need to be, because you can't be drinking and wielding your gun, you know. But I don't think that, even TSA, for that example, I think they take their situations with guns on a case by case. I don't think everyone that has a gun in their check or their carry-on necessarily gets prosecuted. Some do. But I think I think the officers have a discretion to make the determination to whether or not they want to arrest someone and send them to jail. So I don't know that from what I see happening in Sevier County, that's where I practice mostly, and some of the surrounding counties, I don't know that people are being arrested for accidentally carrying a firearm onto a premise that's been posted. And you may have a different or an example maybe or something, but I just don't see it being prosecuted.
Chairman Sexton.
I don't disagree with you. I think you're probably right. But the problem is it's on the books. It's in the Tennessee Code that if someone wanted to, they could. And, we live in a world where you're either on one side or the other, and some can be vindictive on both sides. And if they can take the law and use it to their benefit, then they will. That's my concern with it. As I said, I think you're right. It probably doesn't happen much, if all. I don't know, but the law is on the books, and I think it could be amended to just say no harm, no foul. But if you don't abide by leaving, then you can be charged.
Chairman Farmer.
That's all I have. Thank you for the sponsor.
Representative Griffey, your name was mentioned. Would you like to respond?
I would, thank you, Mr. Chairman. I wonder if maybe, it sounds like the committee may be inclined to entertain perhaps a modified version of this if we maybe roll this bill to the hill, and we probably won't get through with today's calendar, and then come back and maybe we've got a bill that everybody feels more comfortable with or something like that. I just kind of throw that out there for the comment of the committee and the sponsor. Thank you, Mr. Chairman.
Okay, is that a motion?
It is a motion to roll it to the
Okay,
hill.
We've got a motion to roll it to the hill. Do we have a second? We've got a second, and without objection, we'll roll to the hill. Representative Ogles?
Just one comment to the sponsor. Can you look at just one cleanup, just be sure we're not on introducing weapons to like our prisons where those facilities, I mean, everybody knows you're not going to introduce a weapon into a prison, a jail, even law enforcement that goes there knows better to do such thing. Can you kind of look at that and be sure we're not, we don't want, smuggling weapons into facilities is already a nightmare. Let's just be sure we're not doing anything to encourage people to come in and say, oops, you know, I didn't know. You know, and please don't do that.
We can carve,
Okay, thank you.
Chairman Sexton?
we can carve that out, and we've got some other things carved out that I haven't mentioned, but we'll try to clean it up and bring back a bill that's acceptable to the committee.
And Chairman, thank you for working with the committee on this.
My pleasure. Thank you.
Next up is item number 6, House Joint Resolution 757 by Representative Powell. We got a motion and we have a second. Representative, I show a amendment. You still want to run that amendment?
I do. It just makes it.
We got a motion and a second on the amendment. Would you just clarify the
It
code?
just makes a technical wording, a couple of different wording corrections because it
Could you
was
could you
updated.
confirm the code for us?
Yeah, sure. It's 15293.
That's what I show. And we do have a motion and a second, so you're recognized on the amendment if you'd like to address that first.
Yeah, it just makes a few corrections. If I can get that on, then I'm happy to speak.
Okay, without objection, we will add amendment 015239 to House Joint Resolution 757. All those in favor signify by saying aye. Opposed, no. Amendment's added. You're
Thank you.
recognized.
Thank you, Chairman. So this resolution is brought to show support for ratification of the Equal Rights Amendment to the United States Constitution. The text of the Equal Rights Amendment states that equality for rights under the law shall not be denied or abridged by the United States or by any state or on account of sex. The Equal Rights Amendment was passed by Congress on March 22, 1972, and sent to the states for ratification. States across the nation have been ratifying the ERA. Just 2 years ago, Virginia became the 38th state to ratify the ERA, which met the 3/4 threshold. Essentially, what we're trying to do here is encourage Congress to make the ERA the 28th Amendment to the Constitution. Equal rights between men and women are not protected by our Constitution as it currently stands. The right to vote is surprisingly the only right guaranteed to women in the Constitution. The Equal Protection Clause in the 14th Amendment of the United States Constitution has not been interpreted to guarantee equal rights on the basis of sex in the same way the Equal Rights Amendment would. Cases based on sex discrimination currently receive intermediate scrutiny, but receive a higher legal standard with the ERA. Passing the ERA would clarify the legal status of sex discrimination, putting in the same legal categories discrimination on the basis of race, religion, national origin, guarantee equal footing for women in the legal system in each of the 50 states, but also ensure that government programs and federal resources benefit both men and women equally. All citizens deserve an opportunity to reach their full potential. Men and women must have equal rights for democracy to thrive, and therefore ask you to please vote favorably for this resolution, asking Congress to go ahead and adopt the Equal Rights Amendment as the 28th Amendment.
Thank you, Representative Powell. Any questions for Representative Powell? Representative Griffey.
Thank you, Chairman. Thank you, Representative. When is the deadline?
Well, so technically, the Article 5 places no deadline within ratification of amendments. There was legislation, so what this would do is it would take away the deadline and accept the 38th state, Virginia, and make, that's what Congress is considering now. There's a bill that's passed through the House. It's just waiting action in the Senate.
Representative Griffey.
So I'm not clear then, is there a deadline or is not a deadline? And if we pass this, it's going to remove, is there a requirement and accept a 38 who's already passed it or something?
This certainly was just a resolution, so it's not going to require Congress to do anything, it's just recommending. And there's legislation right now before Congress that's passed that would remove the deadline as it stood. To answer your question, there was originally a deadline placed at 10 years. That it was extended to 1982, that essentially this legislation that's before Congress that I'm referencing would remove that deadline.
Representative Griffey.
Thank you. And the other question is, you said it would remove discrimination on the basis of sex, essentially so women have equal treatment. Is that all women? Is that include transgender folks? Or is it sexual orientation? What's your definition of sex?
So I would
Representative
just
Powell.
point you to the, I guess there's interpretation that could be had for that, but it essentially says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex.
Representative Griffey.
Well, my question remains, what is sex? Is it female based upon DNA, XY chromosome, or XX for female, XY for male?
This does not address that specifically, it just says sex.
Well, it's clear.
Representative Griffey.
It's clear that we're at that point of discourse in our society over that issue, are we not? Would you?
Representative Powell.
I would say at that point, if this becomes law, then that would be up to, courts and others to interpret.
Thank you. Thank you.
Chairman Farmer.
Yes, and it's my understanding that Tennessee rescinded this ratification in 1974. Could you enlighten the committee on the basis of that and why we're now, you're asking this body to make a recommendation to the full committee, and the full committee does to the full body to reverse course?
Representative Powell.
So technically, states can rescind, but essentially rescissions have no legal basis. Article 5 does not address rescission, so essentially, once it's passed, that's the way it is, and so essentially, we already passed it as you referenced previously, before the rescission, and so that, and most legal scholars would say, does not count. There's 38 states that have ratified. That's the threshold that's put in the Constitution, and that's been met.
Chairman Farmer.
So Tennessee this has been ratified by the amount of states it needs to be ratified by? Is that what you're saying?
Representative Powell.
Yes, it's met the 3/4 threshold. And there was a rescission, but rescissions are not part
Chairman.
of, are not included.
Chairman Farmer.
And I guess really just, my question is this, since that rescission happened, has this General Assembly done anything to change that course of action?
They have not. That's why I think this sends another strong message.
Okay.
Chairman Farmer.
That's all I have.
And Representative Griffey.
Just one more follow-up on this, and I'm not trying to make light of this, but I think it may have application to real-world, everyday events. So I wake up 3:30, I can't sleep, and there's a women's soccer on ESPN or something playing. But, if you go to the primetime television, you've got men's World Soccer Cup going and hundreds of thousands of fans or so forth. Would this bill demand that female soccer players get paid on the same basis that male soccer players do that are playing a professional sport or any other sport for that matter?
Representative Powell.
This bill does not speak to soccer matches or soccer games or speaks to that. It talks about, treating people equally under the law, not based upon sex.
Representative Griffey.
Well, treating people equally under law, you can't discriminate. So were female soccer players going to be able to demand the same amount of pay as male soccer players? I think that's where we're getting at, and what may be problematic, I think, for majority of Americans.
Representative Powell.
I can't speak to that. All I can say when it comes to women's soccer is I'm proud the United States has won the World Cup in soccer multiple times, and we should be proud of the women in this country. And so that's universal. I think we should treat men and women equally.
Representative Griffey.
Last point, I have 2 daughters, so I absolutely promote women and what they do. So I just want everybody to know that too.
Thank you. And Representative Ogles, you're up.
Thank you, Chairman. My question was answered.
Thank you. And Representative Parkinson.
Thank you, Mr. Chair, and to my colleague, I won't call his name, but on my far right, I'm glad you got that disclaimer in there, man, because you were going to catch it. And thank you for bringing the resolution, and even though we know that it is just that, a resolution, right? Congress is going to, do whatever it is that they're going to do, but we are encouraging them to do the right thing. And the fact that we're even having this conversation is to me is is sad. Actually, you know, it really does. It's disheartening. Let me say it like that. You know, the fact that here we are in 2022 in our state, and you know, we're still having this conversation about, you know, treating people equally. You know, whether people are playing soccer or being a mom at home, or you know, in the workforce, corporate America, in the field with the military fighting our wars. You know, they because of the fact that God placed them here, they deserve to be treated just as equal as anybody else. And I think our Constitution speaks to that.
Oh, you go ahead. I thought you said.
Easy, Mr. Chair. No, I'm just kidding.
Quick on the trigger here.
Yeah, right. Our Constitution, you know, speaks to that, and so hopefully, our men and women that are representing us in D.C., you know, will hear our voice if we get this resolution passed and go ahead and you know, make sure that all people are treated equally. And I appreciate you bringing this, but I'm saddened that we're still having this conversation. Thank you, sir.
Representative Powell.
No, I appreciate those comments. Thank you.
Representative Ogles.
Thank you, Chairman, and to the sponsor. I do appreciate you bringing this legislation, and to my chairman who asked the question if any legislation was brought before this body. Unfortunately, I've seen several times that anything involving employees, human rights, or civil rights, for some strange reason, in the General Assembly is referred to Commerce Committee. And the same large corporations who fly multicolored flags in their lobbies and seem to be advocating or acting like they're advocating for the rights of people, in fact, do not do that. Any piece of legislation that ever expands the rights of employees, protects people in this state, is crushed and is dead on arrival. So I would hope in the future that some of these pieces of legislation are actually crafted in a way where they find their way to Judiciary Committee and the proper committee, rather than going through Commerce, where it's they're systematically put down hard by big business. Thank you.
Representative Powell.
I guess refer that to the clerk's office. I have no say where my bills go, and sometimes I too share your frustration. Things I care passionately about get referred to committees that I know will not be judged as favorably by the makeup of the committees as others. But I certainly understand your frustration there.
Thank you, and Chairman Farmer. And Chairman Curcio.
Thank you, Mr. Chairman, and to the sponsor. Just like other members of this committee, I too have a daughter, and certainly no question about my allegiance to her. But my good friend from Paris did bring up a question about the difference between the use of sex versus gender, and I was following along when you we're talking about women's rights and you're talking about sex, but specifically in your third and fourth whereas clause, you switch to gender and you talk about gender equality. So would it not be better to run this, just to delete those two whereas clauses and just run this as a true sort of like equal rights for women resolution, as opposed to then veering off into gender equality for two whereas clauses and then coming back to sex? It's just kind of confusing to me.
Sure. So, I'm at the will of the committee. So, obviously, if the committee would vote favorably for this resolution, ultimately, my goal is simply that we encourage Congress to take action and ratify the 38th Amendment. Whatever sort of signal we're going to send, I don't want to get into the specifics of the resolution, but that's the ultimate message. It's the bottom line, not necessarily the whereases, whereas it's important to me. So, look, if that helps pass this out, then I'm certainly willing to at the will of the committee, take that suggestion.
Chairman Curcio.
Thank you, Mr. Chairman. Yeah, and I don't know, I don't think we can amend a resolution on the fly, so I don't know if you'd have to roll to the hill or file a new one. I don't know how that works. You'd have to ask the clerks. But I just think, for your intent, and I agree, I mean, I want equal rights for women. My good friend from Paris brings up a good point, which is, do we get some mission creep here and then wind up this thing being confusing? I think shifting to using the term gender in the third and fourth whereas clause and then using sex everywhere else just adds to that confusion. So, I mean, I just wanted to point that out since he did bring it up. So.
Representative Powell.
Sure. Again, I'm at the will of the committee. I know this is the final calendar, so, yeah. So we've got to take action today and see how this goes.
Representative Griffin, I'm sorry, Chairman Kersey, are you finished?
Yes, sir. Thank you.
Okay, Representative Griffin.
Thank you, Mr. Chairman. I'm a no as is, but I'll leave it to the sponsor. What, the suggestion to amendment, certainly. I've got 2 daughters, so if we want to talk about sex and, protecting women, female women, I could be in favor of that.
Representative Powell.
I guess I'll just leave it at this. I have a daughter too, so. So hi, Sophie Powell.
Okay, the question has been called. We're now voting on HJR 757 to send to full civil. All those in favor signify by saying aye.
Aye.
Opposed, no? No. All right, we'll go ahead and do a roll call vote.
Representative Clemens,
Yes.
Curcio,
Yes.
Farmer. No. Garrett. No. Griffey.
No.
Ogles. Yes. Parkinson. Aye. Ramsey. Yes. Chairman Russell.
No.
Representative, you have 5 ayes and 4 noes.
Okay, you go to full civil. Congratulations. Next up is item number 8, House Bill 1943 by Representative Beck. We got a motion and a second. Representative Beck, I show an amendment. Do you wish to run your amendment?
Yes, the amendment makes the bill, Mr. Chairman.
And what's your amendment code?
It is 014849.
That's what I got. And we got a motion on amendment. Do I hear a second? We got a motion and a second. We're going to vote on adding amendment 14849 to House Bill 1943. All those in favor signify by saying aye. Aye. Opposed, no. Amendment passes. It's added. You're recognized on the bill.
Thank you, Mr. Chairman. First of all, committee, the code is silent on a threshold for minor approvals. What a minor approval is if a child is, if a parent is awarded a settlement for a child from a tort, typically, but it can be from other. But this only refers to torts. Today, if your child is in your car and you have an accident, you obviously, being a good parent, take that child to the hospital to get checked out. Anybody who has been to the hospital knows that by the time you get to the emergency room, the radiology, the ER doctors bill, it's going to be $3,000 to $5,000. If they run an MRI, to be safe, it's going to be $8,000 to $9,000. And children may follow up with their pediatrician, they may not. But where we are is that even small amounts are, the defense attorneys are coming up with reasons to have a court approval, or they just say it's their policy to have a court approval. Then you got to take the child out of school. You got to take the parents. You got to tromp down to the courthouse for a formality of the judge approving. I've never been to one where the judge didn't approve it, but I mean that could always happen. But these are cases where the child has been checked out and is doing fine. If it's above $10,000, it requires a court approval. If it's below $10,000 and you are represented by an attorney who can give you legal advice as to what your position is with a minor settlement. Now, a minor settlement, the parents or guardians will still have to sign off, but it will not require a court approval unless the child has a disability. And then any approval, any settlement will require a court hearing. But for anyone who, I know for several of y'all who don't do this type of law, but there's several of you that do, know that this is a formality and we're just trying to make it, while still having the best interest of the child at heart, we're just trying to let the family put this behind them and go forward. So with that, Mr. Chairman, I stand ready to take questions.
Thank you, Representative Beck and Representative Garrett.
Thank you, Mr. Chairman. Representative Beck, it's a great bill. Thank you for bringing this. You're right. I've done some for several insurance companies where we appear in court and they do have to get out of school. You got to spend maybe an hour. Sometimes if there's a large docket, you could be there all day and it really takes 5 seconds to approve the settlement. So I appreciate you bringing this legislation. I'm going to support it. But one question, I did read over the bill, but I didn't catch this until you said something. You said if there is an attorney involved, that this applies in where a kid doesn't have a disability, they can get it approved if it's less than $10,000. What if there's no attorney? What if the parties are pro se and it's still under the $10,000? Is that waived, or is there a process where they have to get approved since there's no attorney involved?
Representative Beck.
They would still have to get it approved.
Perfect. That's what I was hoping you'd say. Thank you very much. I appreciate the legislation.
Okay, we got Representative Parkinson.
Thank you, Mr. Chair. And Mr. Sponsor, I don't do this kind of law. As a matter of fact, I don't do any kind of law. But I did want to thank you for bringing this bill. This is a good bill. Thank you, sir.
Thank you.
Okay, I don't show anyone else. We do have the questions been called. We're voting to send House Bill 1943 to civil full. All those in favor signify by saying aye. Aye. Opposed, no. Bill passes.
Thank you, Mr. Chairman and
civil
committee.
full. Next up, item number 9, House Bill 2724 by Representative Miller. Okay, Representative Miller's not here. We'll roll it to the Hill. Next up is item number 10, House Joint Resolution 760 by Representative Miller. And he's not here. Without objection, roll to the Hill. Item number 11's already been rolled to the Hill. Next up, item number 12, SJR 1 by Representative Ramsey, Chairman Ramsey. We've got a motion and a second. Chairman Ramsey, you are recognized on SJR 1.
And excuse me, thank you, ladies and gentlemen. This resolution is a constitutional change which has 2 changes it recommends for the Tennessee Constitution. In 2014, the resolution is about accountability, and in 2014, we removed the popular vote for Supreme Court justices, and how that affected our state attorney general appointing process is Senator Yeager feels like that removes some of the accountability to the public. So the process now, Tennessee is a unique state in the fact that the candidates for Attorney General are chosen by the Supreme Court and not the governor. What this resolution would do is, in changing the Constitution, is it would say that that process would remain the same. However, the vote from the Supreme Court in nomination would be a public vote. It would be transparent and publicly recorded, and that the nominee would be confirmed within 60 days by the General Assembly, or within 60 days of the convening of session, or by default if the General Assembly does not take up the issue. With that explanation, I will stand for questions on the resolution.
Thank you, Chairman, for that explanation. Any questions on the resolution? Questions been called on the bill, on the resolution. All those in favor signify by saying aye. Aye. Opposed, no. No. Noes have it. Bill fails.
Thank you, ladies and gentlemen.
All right, next up is item 13, House Bill 1730 by Chairman Curcio.
Thank you, Mr. Chairman.
We got a motion. Do we have a second? We got a second. Chairman Curcio, you're recognized on House Bill 1730.
Thank you, Mr. Chairman and committee. Members, under current law, Sessions judge may postpone a trial for forcible entry and detainer to any time not exceeding 15 days. So when you've got a dispute there between a landlord and a tenant, they can only delay that for up to 15 days. The postponement must not be longer for that time period unless it's agreed upon by both parties, or if no civil court is being conducted, or upon request of the plaintiff, the party making the application for postponing paying the costs. However, we do have some jurisdictions where special housing courts have been created to address landlord-tenant issues, and in those courts, these trials are being postponed for extended periods of time, even if civil court is being conducted. So it's not like it's not safe to conduct court. Civil court is going on, but these special courts are not meeting, so it's going on for greater than 90 days in many cases. So House Bill 1730 simply specifies that for purposes of postponement of trial and forcible entry and detainer proceedings, the term civil court includes diversionary courts created for special civil proceedings. So that way, everybody's subject to the same 15-day limit.
Thank you, Chairman. And we're getting questions for Representative Griffey.
Thank you, Mr. Chairman. Thank you, Chairman. This is a good bill. So what happens if our Supreme Court imposes limitations on in-person hearings due to another COVID deal or something? What do we do?
Chairman Curcio.
Thank you, Mr. Chairman. This bill doesn't really change that, so we're just making it apply to the special court. So it's my understanding that if court's not meeting, now a Zoom meeting or a virtual meeting is different. The court is still meeting, but if the court is just not allowed to meet, then this 15-day deal does not apply. But if they're meeting, then they can't delay it for more than 15 days.
Representative Griffey.
And so, and it says if no civil court is being conducted, my presumption is that that very next time that court does meet, they will have to have a hearing on that unless both parties agree to extension.
Chairman Curcio.
Thank you, Mr. Chairman. Yeah, that's my understanding.
Thank you. That's a good bill. I support it.
Thank you, sir.
Thank you. Any other questions? And Representative Garrett.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for bringing this legislation. I agree with Representative Griffith. This is good legislation. I noticed that it's a may, so it's permissive. In other words, it's not going to prevent if the parties before the court agree on a certain trial date that's 30 days, 45 days, or whatever down the road, that's you're not handcuffing the judge to allow something happening maybe 2 months down the road if the parties agree to it.
Chairman Curcio.
Thank you, Mr. Chairman. Yes, sir, and that's current law. So we're not changing anything about that. We're just clarifying that special courts, diversionary courts that are set up just to handle these types of cases are also subject to that 15-day.
Perfect. Thank you. Thank you very much, Mr. Chairman and Mr. Chairman.
Okay, that's all I see on the question list. So we're voting to send House Bill 1730 to full civil. All those in favor signify by saying aye.
Aye.
Opposed, no. Bill passes. Congratulations, going to full civil. Next
Chairman
up
Committee.
is number 16, House Bill 2435 by Chairman Curcio. Do I have a motion? I got a motion and a second, and I do show an amendment. Chairman, do you want to?
Thank you, Mr. Chairman. Yes, the amendment I wish to move is coded 15409.
That's correct, and we do have a motion and a second on the amendment. Would you like to add it? Does it make the bill?
Yes, sir, it does make the bill.
Okay, we're voting to add Amendment 15409 to House Bill 2435. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. You're recognized on the bill.
Thank you, Mr. Chairman and committee. Members, this deals with when regulation changes locally that would change a property. Say you have a piece of commercial property that because of a change in local regulation becomes deemed a residential property. At that point, the owner has a decrease in value. And right now, there's not a clear remedy for this. Basically, if you're upset about it, you've just got to sue the municipality. Obviously, that's very costly. What we're trying to do is set up just a process whereby the value of that property or the value amount of the loss can be determined. So that's what this bill establishes, and I'd be happy to answer any questions.
Thank you, Chairman. Do we have any questions? And we got one by Chairman Farmer.
And thank you, Mr. Chair, and thank you, Chairman Curcio, for this. I had this legislation and ran into some issues locally, and Chairman Curcio, thank you for continuing to run this legislation. I just had a question there. I think you brought up a point that I really hadn't thought of. Now, could this potentially save cities and municipalities litigation costs and monies by having a direction to move forward in outside of the court process, or how's that?
Chairman Garcia.
Thank you, Mr. Chairman. Yes, sir, I believe so. I mean, I grew up in a household where we always tried to find another avenue apart from just lawyering up and suing somebody, and so that's kind of what this is meant to get at. Is just, hey, look, we're all friends here. We all live in the same town. Let's just figure out what this change in regulation really does to my bottom line, and then let's negotiate it out. So it's I believe it would save the municipalities quite a bit of money.
Okay.
Chairman Farmer.
And thank you. That's all I have.
Okay, Representative Griffey.
Thank you, Mr. Chairman. Do we have anybody here to speak on this bill?
We do not.
Okay.
We got a question here. Do you want to withdraw it or?
Real quick.
Yeah. Okay. Chairman Ramsey, you recognize.
And thank you, Mr. Chairman, and I appreciate the discussion that's gone on a long time with this bill. My municipalities do not feel like this would be anything except a burden, and they have requested that should the bill go forward, I would exempt them from the bill. So with that statement, and I don't. I know the specter of saving money has been put forth, but my guys don't feel like that's going to be the case. Thank you very much.
Thank you, Representative Griffey.
Thank you, Mr. Chairman. And I've had some municipalities contact me and indicate that this would be burdensome for them as well. And let me say this, because it looks like to me that it sets up a process so people can get into court and resolve these differences, which I'm in support of. But maybe we should pass it here. But when we get to full, if anyone has any opposition to it, they'll sign up and have an opportunity to testify to the full committee. And let's hear if there's any countervailing arguments and what problems this might cause. Let's hear them out and then resolve it there. So that's all I want to say. Thank you.
Thank you, Representative Griffey. And not seeing any other questions, we're voting to send House Bill 2435 to full civil. All those in favor signify by saying aye.
Aye.
Opposed, no. Ayes have it. Full civil. All right, members.
Thank you, Mr. Chairman and committee.
Thank you. The remaining bills will be rolled to next week's calendar, and without objection, we will be adjourned.